Tonight, a CNN exclusive. The Justice Department now asking a federal judge to force two top lawyers from Donald Trump's White House to testify about conversations with him. Those lawyers are former White House counsel Pat Cipollone and the deputy White House counsel at the time, Patrick Philbin. This as Trump has waged a secret court fight to block former advisors from testifying before a federal grand jury investigating the events of January 6th. Our senior justice correspondent, Evan Perez, is out front. And Evan, this could, I think, have a major impact on the investigation if the Justice Department succeeds and gets these former Trump lawyers to testify, right?
Right. It really does have the possibility of getting prosecutors into the inner circle of Donald Trump and his White House. Pat Cipollone was the former White House counsel. Patrick Philbin was his deputy. And look, they were there during some of these conversations as the former president was trying to impede the transfer of power in 2020, which is after the 2020 elections, which is exactly what the prosecutors of the Justice Department are investigating, Aaron. And the Justice Department so far has been winning these secret proceedings that are going on at the courthouse here in Washington. They got Greg Jacob and Mark Short, former aides to the former Vice President Pence, to come back in and answer questions. These are very, very important questions about conversations that they had with the former president. So the fact that they're winning these fights does bode well for the Justice Department as they try to get the compelled testimony of Cipollone and Philbin.
All right, Evan, thank you very much. And I want to go now to Lawrence Tribe, the constitutional law professor at Harvard Law School, who also consulted House Democrats for the impeachment of then President Trump. So, Professor, what does it mean for Donald Trump if the DOJ succeeds here and gets in this inner circle, as Evan describes it, via Pat Cipollone and Patrick Philbin's testimony?
It means he's in deep trouble, and there's no reason the Justice Department should not succeed. When a grand jury demands the testimony of people who have firsthand knowledge of someone who appears to have been involved in an insurrection and a seditious conspiracy, they're entitled to get that information. If there were an executive privilege for a former president, and that's doubtful, it would be overcome by the context. The information is needed for a criminal investigation. It was unanimous in the U.S. Supreme Court in both cases where the issue arose that the need for information in a criminal proceeding trumps, no pun intended, any executive privilege. So there is no basis for them to resist the order that they're going to get from the department's motion with the court, and there's no reason for the court to deny that motion.
So obviously that is significant. There's also what's going on in the grand jury investigation in Georgia. You've been very critical of Supreme Court Justice Clarence Thomas giving Senator Lindsey Graham a temporary freeze from testifying before that grand jury in Georgia. Why do you think Thomas's decision, which, by the way, went against what two other courts had already ruled, which is that Graham should go ahead and have to appear before that grand jury, why do you think Thomas doing this is so egregious?
Well, it's egregious because it's illegal. It wasn't the fact that he granted Lindsey's request. Even denying Lindsey's request would have been unlawful, because 18 U.S. Code section, actually 28 U.S. Code section 455 says that a justice or judge, but it includes a justice, and the language it uses is shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. So even denying Lindsey's request would have been wrong. He should have just handed it over to another justice. But there's another part of 28 U.S. Code that is slam dunk applicable. It says that a justice shall, and I keep emphasizing the word shall, it's not discretionary, disqualify himself in any proceeding in which, and I'm going to quote the language, his spouse is known by the justice to have an interest that could be substantially affected by the outcome. Now, we know that Ginny Thomas has an interest. She made it clear. It's not even secret. She was at the January 6th rally. She sent at least 29 texts few weeks earlier to the Chief of Staff, Mark Meadows, urging him to back up the president's effort to prevent the transfer of power to Biden. She said the whole Biden family should be tried for treason. Then there were texts that she sent to the legislators of Arizona and Wisconsin, urging them to submit phony electoral slates to prevent the transfer of power. So she is intimately interested in the outcome of the proceeding in Georgia, where the same question, the question of whether former President Trump and members of the House and Senate, including Senator Graham, were engaged in an effort to strong arm people like Raffensperger
Right.
to create phony votes. So she's in the middle of it. He has to know that. It's not a question of their pillow talk. Everyone in the country knows it.
Right.
And
Well, there's
because
a-
he knows it, he's got to not take part. It's open and shut.
Well, as you say, it's not discretionary. It's shall, and that operative word it carries so much weight in this case. Professor, thank you so much.
Thank you.